Um, we are going to take a plea, is my understanding, for you remotely from the jail. Are you okay with that?
Yes.
Okay. Mr. Hedspeth, the only reason I need you to answer out loud is you should be able to see, but up in the right or up in your left corner, I think, is the court reporter, and she's taking everything down. All right.
Yes.
All right. Are you willing to proceed? Have you had a chance to talk to Ms. Jones about what we're doing today?
Yes.
Oh, no, Your Honor, he's
I'm
represented
sorry.
by me, Terrence Miller.
Okay. Have you had a chance to talk to Mr. Miller about what we're doing today?
Yes, I have.
Has he explained everything to you?
Yes.
Are you okay handling this remotely? That is by video from the jail without you being here in the courtroom?
Yes.
Okay. And have you talked to Mr. Miller about that?
Yes.
Okay. Are y'all ready to proceed?
Yes, Judge.
We are, Your Honor.
All right. Now, Mr. Hedspeth, what we're going to do, if you agree to this, is I am going to take down your answers on this plea of guilty form that you should have gone over with Mr. Miller. Did you do that?
Yes.
Okay. And are you okay with me putting your initials next to the answers on this plea sheet that Mr. Whitenauer is going to ask you about?
Yes.
All right. And are you okay going on a copy of the indictment since you're there and I'm here?
Yes.
All right. Go ahead, Mr. Whitenauer.
Yes, Judge. Mr. Hedspeth, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I am going to be asking you some questions today. If you do not understand the question or are having difficulty hearing the question, please speak up and let me know.
No.
Understood?
Yes.
All right. First, if you would, please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Please lower your right hand. And sir, I do have a few additional questions to ask you. Do you waive your right to an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes.
All right. And Your Honor, the state waives an original signature on the indictment and authorizes the court to sign on its behalf.
Okay.
Sir, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you?
22.
How far have you gone in school?
GED.
Are you able to read, write, and understand the English language?
Yes.
And sir, do you understand that you're charged with the following offenses? In indictment 19 SC 173063, charged with burglary in the first degree.
Yes.
And an indictment 19 SC 173066, you're charged with, excuse me.
Mr. Whitenauer, I think you have the indictments backwards.
I apologize. And ending 066, burglary in the first degree, and an indictment ending 063, willful obstruction, 2 counts, simple battery against a police officer. Yes, are you aware of those indictments, sir, and those charges?
Yes.
All right. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And sir, have you gone over with your attorney the waiver of rights form?
Yes.
All right. And have you had enough time to speak with your attorney, Mr. Miller, about all the facts and circumstances known to you regarding the charges in both indictments, including any potential defenses?
Yes.
Okay. Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
And counsel, do you waive formal reading of both indictments?
So waived.
And do you waive any and all defects in both indictments?
So waived for the purposes of this plea.
Okay. And sir, has your attorney advised you the minimum and maximum sentence for each charge that you're pleading to today?
Yes.
Okay. And just give me a moment. With respect to indictment ending 063 on the willful obstruction of law enforcement, that is a sentencing range of 1 to 5 years in confinement. And on simple battery against a detention officer, that is 12 months in confinement. Do you understand?
Yes.
All right. And with respect to the other case, the burglary in the first degree, that's going to be a sentencing range of 1 to 20 years. Do you understand that?
Yes.
All right. You understand that this is a negotiated plea of guilty, which means that the state will make a recommendation to the court for sentencing?
Yes.
And do you understand? Have you discussed that with your attorney?
Yes.
All right. And are you aware that on the indictment ending 066, burglary in the first degree, the state will be offering a reduction to criminal trespass, recommending 12 months probation, and that you not return to the property? With respect to the indictment ending in 063, asking for 5 months, or excuse me, 5 years probation with certain conditions, including GED, school, curfew, no drugs, alcohol, community service. Do you understand?
Yes.
All right. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges in indictments 19 SC 173066 with the reduction to criminal trespass?
Guilty.
And how do you plead to the charges in indictment 19 SC 173063?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file what is called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, with respect to indictment 19 SC 173066, if that case were to have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about November 11th, 2019, the defendant was found in the home of the victim Abdir, A-B-D-E-R, Abdurrahman, A-B-D-E-R-R-A-H-M-A-N, that he called the police when he arrived at his property, saw a black male enter the rear door and lock it from inside. He eventually that person left the house. Officers responded. They determined that there were some bikes associated with those people that were in the house. They placed them outside and eventually saw the two individuals that had been in the house earlier. That would be Mr. Hesketh and his co-defendant, Christopher Coppage. I spoke with the victim in this case, and he advised that he felt like these two individuals were homeless, that there probably wasn't an intent to commit a theft in the residence. And it's for that reason that I offered Christopher Coppage a criminal trespass plea. We're making the same offer here in this case, Judge. There was some minor damage to the house inside. However, this owner of the property seemed fairly forgiving and said he was not seeking restitution. And so that's the basis for the reduction there, Judge. With respect to indictment 19 SC 173063, this came on the same day as the defendant's arrest when he was being booked into the Fulton County Jail. Let me pull that. In this case, Judge, sorry, trying to, in my limited space here, get through the different files. In that case, Judge, detention officer R. Bradley, B-R-A-D-L-E-Y, was assigned to the intake unit and was dealing with the defendant, Demetrius Hedspeth. He was kicking a door in the holding tank, complaining it was too crowded. As the officer tried to handcuff the defendant to escort him to another cell, he resisted, began to swing his fists at another officer, Guyton, G-U-Y-T-O-N. He continued to throw punches with closed fists. They managed to get him to the ground. During this struggle, the defendant turned and stepped towards Officer Bradley and spat directly in his face. That is the factual basis for the charges in this indictment. Judge, with respect to the criminal trespass, Judge, this is a negotiated plea. We are recommending 12 months probation, and they did not return to the property, which is going to be, sorry, Judge, flipping back between files here.
That's all right. I'll let you put it on the record in a minute. What's his criminal history?
Yes, Judge. For Mr. Hedspeth, he does not have any felony convictions. He does have 7 prior arrests. I was looking over those this morning. One of those is for a conviction of family violence battery. The others have the other arrests, which do include some arrests for other simple batteries, were dismissed, or there's no disposition listed on the GCIC, Judge.
Do you understand the nature of the charges against you?
Yes.
Are you now under the influence of any alcohol, drugs, or any other substances?
No.
Has anyone made any threat or promise to influence you to plead guilty?
No.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, and the right to appeal your case and be represented by counsel if convicted by a jury. Do you understand that by pleading guilty, you're giving up all of those rights?
Yes.
Do you understand that if you are not a U.S. citizen, a plea of guilty will have an impact on your immigration status?
Yes.
Do you understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate?
Yes.
How do you plead to the charges, guilty or not guilty?
Guilty.
Are you in fact guilty? Are you guilty, sir?
Yes.
Is your plea made freely and voluntarily?
Yes.
Mr. Miller, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
I am, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered, and I will accept your guilty plea. Go ahead, Mr. Miller.
Thank you, Your Honor. Before the court today via Zoom is Mr. Demetrius Headsmith. He is 22 years old, Your Honor. He's lived in the metro Atlanta area his entire life with his family, his mother, father, and 4 siblings, Your Honor. Prior to this arrest, he lived with his father, Demetrius Lowe. Also prior to this arrest, for about a year or so, he was employed by the Mercedes-Benz Stadium where he worked in the concessions, Your Honor. Although Mr. Headsmith did not obtain a high school diploma prior to this arrest, while in the custody of the Fulton County Sheriff's Department, he has obtained his GED, Your Honor. So he does see that as a positive from this experience, Your Honor. When it comes to the case ending in 0660 burglary case, Your Honor, the explanation for Mr. Headsmith and Mr. Coppers, Your Honor, is that they were coming back from a party late at night, Your Honor. They was walking from the west end back to East Atlanta, Your Honor, and it was very late at night. Their impression was that the home was vacant, and so in order to seek shelter, they did enter the premises of that home, Your Honor, and they stayed there overnight. It was not their intention to take anything nor damage anything in the property, Your Honor. Therefore, there was little to no damage, nor was there anything taken from the property, Your Honor. And so we would ask the court to accept the negotiated plea between the state and defense counsel, reducing their charge from burglary to criminal trespass with the sentence of 12 months probation, Your Honor. Mr. Headsmith does plan to obtain employment if he is released, Your Honor. Given that he receives his GED, Your Honor, he does expect his job prospects to increase because of that, Your Honor. So we ask the court to accept the negotiated plea between the state and defense counsel on both cases, Your Honor. Thank you.
All right, on 19 SC 173063, Mr. Whitenauer, it looks like both of these obstructions are felonies. Is that correct?
Yes, Judge. I believe so.
Count 1, 5 years probated. Count 2, 5 years probated consecutive. Count 3, 12 months probated concurrent. On 19 SC 173066 on the criminal trespass, 12 months probated concurrent with 19 SC 173063. Special conditions of probation to include: you have to be employed, in school, or a combination of both. In the next 2 years, you have to either be enrolled in college or some sort of trade. I don't care which one you do, but you need a skill besides a GED. You'll report to court as directed, participate in the My Journey Matters program. You'll report to court on August 7th unless you receive other instructions from your attorney, all right? August 7th, 8D at 9:30, all right? You're not sure, make sure you call Mr. Miller and check with him, all right? There will be random drug screens, a 10 p.m. to 6 a.m. curfew for the time being. If you get a job that requires you to work later than that, we'll deal with the curfew at that time. You just need to let Mr. Miller know. You have to stay away from the location where you entered the house.
And for the record, Judge, if I may, that's 940 Mason, Mayson, Turner Road, Northwest, Atlanta.
Okay, you have to stay away from that address. Do you have any questions, Mr. Headsmith?
No.
Okay.
Your Honor, I also would like to add, and my apologies for not mentioning, because Mr. Hesper does not have any felony convictions, we do seek first offender treatment on that case, Your Honor, on the obstruction, the felony obstruction case, Your Honor.
Mr. Whitenauer, any objection?
No objection, Judge.
All right, do you understand what first offender is, Mr. Hedspeth?
Yes.
Okay, you understand that if you get in any trouble at all or violate any of the conditions of your sentence, you could be adjudicated guilty and sentenced up to 12 years in custody. Do you understand that?
Yes.
Do you still want to be treated as a first offender?
Yes.
Have you ever pled guilty or nolo contendere to a felony in Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
All right, you will be treated as a first offender. Understand that there are risks with that, okay? So this is the time to quit getting in trouble. Okay? So if you keep getting in trouble, it's going to follow you and eventually you're going to end up in the prison system, okay? All right, good luck. It's a different place out there right now, so make sure you talk to folks that understand what you should and shouldn't be doing when you're released. All right. All right, I see Mr. Melnick's on.
Good morning, Your Honor.
Good morning, how are you?
I'm good. How are you?
Good. Is Kenneth Wilcox on 4, where we are, 4 North?
Yes.
Can we, you want to go, any objection to letting us deal with Mr. Melnick's case real quick since he's on?
That's fine.
All right, let's get Mr. Wilcox.
And Your Honor, that concludes my business with the court today. May I be excused?
You may, yes, and we'll have a meeting next week.
Yes, Your Honor. All right. Thank you. You have a good day.
You too. Have a good weekend.
Bye, Terrence.
Bye-bye.
While we're waiting for Mr. Wilcox, I think Ms. Stevens probably told y'all I will have to jump off for a few minutes right after 10. We'll have to take a quick break. We'll leave everything set up and on, and I'll be off as the other call as quickly as I can.
Okay. That's fine, Judge.
We'll be getting an update from the Chief Justice on everything going on.
Okay. Gotcha. What's up, Morgan? You all right? You're right here. You're right here, Bernie. Everywhere.
Mr. Melnick, did you do your Clayton County via Zoom as well?
I did.
How's that
Yeah.
working for you guys?
I love it. I can't speak for everybody else, but I absolutely love it. Not having to drive and park and sit in court and wait for 25 other cases to get through.
We're ready now, Judge. Here's Mr. Wilcox.
Good morning, Mr. Wilcox.
Good morning, Mr.
Good morning, Judge.
We are conducting this hearing via Zoom, and I am in the courtroom with the deputy, and we are streaming it on YouTube. Are you okay going forward and not being here in the courtroom?
Yes, ma'am.
Okay. Your attorney, can you see him?
That's me with the glasses with the fluorescent lights in the background.
Yes, ma'am.
Okay, you can see, have you had an opportunity to speak with Mr. Melnick?
Yes.
Okay, go ahead, Mr. Whitenauer.
Your Honor, this is a probation revocation hearing. I've had some opportunity to speak with Mr. Melnick about the case. We were unable to reach an agreement. So I guess kind of need to address whether there's a stipulation to the offenses alleged, or if we'll be having a full hearing. I do have Mr. Or Officer Calhoun here. I don't see his video. I did earlier when we first logged on, but he is
See him.
available.
He's on mine.
He's
Okay.
on mine now.
Okay. So I guess there he is. I see him now too. So I guess first we just need to address that threshold issue.
Mr.
So
Melnick?
the violations, as I understand it, are failure to complete RSAT. Was there anything else, Mr. Whitenauer?
Failure to participate in GED classes or take medication as
That's right.
directed.
That's right. And that was all part and parcel of the RSAT program. No, that is
Actually, the IRSAT, just for the record, the
Okay.
integrated RSAT.
right. It is a stipulation with regard to those violations. We would just like to be heard on disposition, Your Honor.
Okay, Officer Calhoun, why don't you hold on for just a minute before you leave us, okay? Just let us get through this. I realize it's a stipulation, but I may have some questions about what went on, okay?
Thank you, Your Honor.
Go ahead, Mr. Melnick, or Mr. Whitenauer.
Yes, Judge, if I may. So this case, 18 SC 160588, Judge, was indicted as an aggravated assault. The defendant entered a plea of battery. Now, he was sentenced to IRSAT, and based on my review of the documents that were provided by Officer Calhoun, and which I shared with Mr. Melnick, it was just 2 days after he was transferred to the IRSAT program that it's alleged that he assaulted another inmate. And then in the next 5 months, that he was in another 2 fights while in IRSAT. It seems that he did not take advantage of this program. Officer Calhoun may want to chime in about some of his disappointment in him not taking advantage of this opportunity, the limited bed space of the IRSAT program. Your Honor, I would note that this defendant does have 7 felony convictions from 2008 until 2018. A variety of theft by receiving, possession of cocaine, robbery, again, possession of cocaine, sale of cocaine, criminal damage to property, and theft by receiving. And speaking with Mr. Melnick, we tried to work out some sort of resolution of this. I had some concern about him being released, given the violent offense that he's under sentence for and the alleged violence while in the IRSAT program.
And a robbery conviction.
I did not see that, Judge.
You just said there was a robbery conviction.
I apologize. Yes, from 2009 in Fulton.
Okay.
Yes.
Okay.
So the state does have some concerns about being released. Initially, I was recommending 2 years to revoke. And speaking with Officer Calhoun, he felt more strongly about it and was recommending a revocation of the balance. And if Your Honor would be so inclined, I do think that Officer Calhoun can provide some context to this case and to his position.
Good day, Your Honor.
Hey, how are you?
I'm very
Go
well.
ahead. What can you tell me?
As stated, the defendant was terminated from the program for fighting on 3 separate occasions. On one of those fights, there was a significant injury to Youngblood, defendant Youngblood, by hitting him in the head. I do not have the records of that, but I do have it noted that the defendant was hit on the head. And as it relates to bed space, it's incredibly difficult to receive bed space. These programs are incredibly valuable to the court and to the community. And it's just really disheartening when we have defendants that don't take advantage of these programs, and we lose the bed space for someone who's not appreciative of what the court is trying to do to assist the defendant in his growth and bettering himself. I also have a case note here that on January the 10th, 2020, the defendant refused to participate in GED classes as ordered by the court as well. So the defendant was, for the most part, non-compliant, fighting in the program and refusing to participate in GED classes and receive his GED. to better himself, Your Honor.
How much time's left on this?
Your Honor, the defendant has a remaining balance on probation of 4 years, 6 months, and 24 days from today.
Can I interject here?
Of course, I was going to give you, I just wanted to have those notes before I was
understand.
obviously going to let you speak, Mr. Melnick. Go ahead.
So just with that last point, he was sentenced to 5 years probation on May, I want to say the 18th of 2018. He's been in continuous custody since October the 4th of 2017. So I don't know, with a 5-year probated sentence, how he would still have 4 years remaining on probation.
It was probably a consecutive sentence, my guess is, because there was also a theft on this.
Uh-huh.
I know how I sentence with his record. I'm confident it was probably a consecutive sentence, which would explain why there's that much left. Mr. Allen, you're nodding your head.
Affirm, Your Honor.
That's what I figured.
So
that's why.
I understand, Your Honor. So I need to take a look at what his credit for time served was. Unfortunately, I don't have access to all of those records. Obviously, I guess that's one limitation of conducting hearings in this manner.
Mr. Melnick, I'm just pulling that up right now, so I think I can answer that question for you.
Okay.
I'm looking at the final disposition now, and it does appear that sentenced to 5 years probated on theft by taking and 12 months probated consecutive to count 2, the theft by
Okay, so the
taking.
12 months is consecutive. Got it.
Yep.
Correct.
That makes sense then. Okay. So, Your Honor,
Was he on probation as well? How did we put him in IR sat with a straight probated sentence?
That was the sentence of the court, Your Honor. It was a 12-month probated sentence consecutive to count 2 of 5 years probated, which would give him a global sentence of 5 years and 12 months probated, with the special condition to ensure and complete the IRSAT program, Your Honor.
Okay, got it. Go ahead, Mr. Melnick.
Thank you, Your Honor. So I've spoken at length with Mr. Wilcox about this situation. Obviously, on the face of it, it would appear that Mr. Wilcox did not take advantage of a sentence, of a opportunity to improve himself. He did complete 8 months in RSAT. And I was wrong about, he was sentenced in November of 2018, but he didn't actually get into the RSAT program until 2019. So he sat in jail for a pretty extensive period of time waiting for bed space to open up in RSAT. And I know that that's just the nature of how things work. So he's been in continuous custody for an extensive period of time. So, Your Honor, with regard to the 3 incidents that are alleged in the petition, I asked Mr. Wilcox about that. None of those incidents resulted in any criminal charges being taken out on Mr. Wilcox. And obviously, prison is not always the most pleasant place in the world to be. There are going to be conflicts. It's just inherent in human nature when people are in closed quarters, people who obviously are individuals who might have other issues. But in none of those cases were any sort of criminal charges taken out on Mr. Wilcox. Even the incident that Officer Calhoun has referred to, where there may have been some sort of an injury. With regard to the other 2 incidents, I don't believe that there was any sort of injury. So when it's characterized as a fight, I think it's more just a disagreement between 2 inmates at a facility. Your Honor, Mr. Wilcox does have several mental health challenges. He is bipolar and schizophrenic. They had been prescribing medication for him while he was at the facility where the RSAT program is located, but it is my understanding that the medication that they provided to him had some pretty significant side effects that caused it to be debilitating for him to continue taking the medication. Mr. Wilcox.
I'm making an educated guess, Mr. Melnick, but if I was true to form when I had Mr. Wilcox in front of me, I would bet in the transcript it will say that I told him that if his medications made him feel bad, he should talk to his doctors about them, because I do that on a very regular basis with my folks with mental health challenges.
Your Honor, I know that because I've appeared before you enough to, I know you've said that, but I think the reality is that sometimes the prison system is not quite as responsive to individuals as we would like for them to be. Mr. Wilcox has indicated to me that he mentioned the side effects that he was having to the medical provider at the facility, but unfortunately, it was still the same medication that he was provided. Your Honor, Mr. Wilcox, in my dealings with him, has been highly motivated to improve his life and to try to get this sort of behavior and this sort of circumstance behind him. Before he even had hired me, he had been in touch with a program at the Hope House, and I have contacted the Hope House about how they would accommodate individuals. They don't have, right now with the social distancing, they're not doing actual inpatient or in-person, but they're doing in-person counseling, but they're not having people actually stay at the facility. But what they're having people do is come in on a regular basis, whether it's every day or 3 days a week, to meet with counselors and to provide services to the individuals who need them to get past whatever issues they have and to help to comply with whatever conditions the court would require. Mr. Wilcox, as I said, himself sought out the Hope House, and they have been in contact with me. So he's been in continuous custody since October of 2017. By my calculations, that is 2.5 years, almost exactly 2.5 years. He did have to wait, I think, 8 months for bed space at RSAT to open up. And then obviously he was in RSAT for about 8 months before he was removed from the facility. He's been back in Fulton County since September 9th of this year. So he has now been in the Fulton County Jail for about a month and a half, waiting for this hearing, to have a hearing in front of you. He does have job opportunities available to him upon his release. He has worked throughout most of his life. And Your Honor, with regard to, well, I think that's really everything that I have to say regarding the petition itself. The only other thing I can say is that, like I said, I've talked to Mr. Wilcox extensively. He really wants to try to improve himself. He wanted to go into RSAT and get the drug and alcohol counseling that would have been provided there. I would ask you to consider the length of time that he has spent in jail already. You know, I mean, I understand that he didn't do everything that he was supposed to do, but he did complete 8 months of RSAT. I think that should go a long way towards some level of mitigation rather than revoking the balance of his sentence. I think part of his sentence was also for him to report to My Journey Matters upon his release, if I remember correctly. Mr. Wilcox, is there anything else that you'd like to say?
I think we would need to swear him in before.
I'm sorry, I can do that. Mr. Wilcox, can you hear me?
Yes, sir.
Raise your right hand. Swear or affirm the testimony and evidence you're about to present in this matter before the court shall be the truth.
Yes, sir.
All right, lower your hand. State your name.
My name is Kenneth Wilcox.
Okay, we can hear you with the mask on, so if you want to keep it on, that's fine. At least I can hear.
Aaron.
Is there anything you'd like to say?
Yes, sir.
Go ahead.
My name is Kenneth Wilcox. Mr. Melton said, I've been locked up almost 3 years. I've been locked up since 2017. And I really have learned my lesson. I really have been improving. I did 8 months of the program. When I first went into the program, they stopped down weeks. So when they stopped down weeks, they brought us our time back. They gave us like a month earlier. So I was in green phase. When I just got terminated from the program, I made it all the way to green phase. So in green phase is no more programming. Like, only thing we doing is green phase is watching movies. And I ain't missing now class, period. The only time I didn't go to, the reason why I didn't go to GED, because I got a learning disability. And the lady teach out. And I can't understand that she was saying. And then she told me that I wouldn't pass if I didn't know a certain amount of stuff. So when she told me that, I kind of gave up. When she told me that, I was like, it really wasn't no use to me going. So, I mean, that's the reason why I got kicked out of GED. I mean, the reason why I wasn't going to GED. And for my medication, I had a side effect to the medicine. Every 3 months, the mental health doctor comes see you. So instead of me taking my medicine, I just refused it until my 3 months is up, so I can come see the mental health, the mental health lady or whatever. So that was one of the reasons I wasn't taking my medication. And like with the fight situation, I mean, like I got into 2 fights while I was down there. When I first got down there, the dude was nagging with me, and we got to fight or whatever. But I can promise you, like Mr. Judge LaGrua's, I wasn't on no attention that I was trying to change myself. I was trying to be a better person. I mean, stuff just came my way.
Thank you. Well, I can tell you this, when I get to IRSAT or RSAT, it's a last resort for me. And with his record, I think that the best thing to do is just revoke the balance and let him move on. So that will be the order. So Officer Allen, I don't think you need to speak with him since I'm revoking the balance, correct?
Correct, Your Honor.
All right. All right, that'll be the order of the court. Good luck, Mr. Wilcox. I hope you stay motivated. Thanks,
Thank you,
Mr.
Judge.
Melnick.
Thank you, Your Honor.
Good to
Johnny,
see you. Have a good weekend.
Thank you.
Thank you, Your Honor. That concludes my business before the court. May I be released?
You may. Thanks so much for being with us.
Thank you again, Your Honor, and stay safe.
You too. Thanks.
Your
Do
Honor.
we have, yes, go ahead.
I'm sorry, I just wanted to be cognizant of your time and the call being 9:45 or 6. If we wanted to take a break even before that 10 o'clock or.
No, I've got, they're going to let me know when they're ready. So we've probably got another 20 plus minutes. Let's go ahead. Who do we have now?
Michael Williams. Good morning, everybody.
Good morning, Mr. Williams. How are you?
I'm doing good today.
Good. I'm glad to hear it. My name is Sean LaGrua. I'm the judge on your case. All right.
Yes, ma'am.
All right. We are doing this via Zoom and it is streaming on YouTube. Are you okay with that?
Yes, ma'am, I am.
Are you okay with not being here in the courtroom while we try and get through this plea?
Yes, ma'am, I am.
And you can see your attorney, Ms. Jones, on the monitor, correct?
Yes, I see her.
And you've had an opportunity to speak with her, correct?
Yes, that's correct.
All right, for us to be able to do this, what we have to do is we have to go forward on a copy of the indictment, not the original. Are you okay with that?
I'm okay with that.
All right, and are you okay with me putting your initials on the plea sheet that Ms. Jones talked to you about?
I'm okay with that.
And are you okay with me putting your name on the indictment for you?
Yes, I am.
All right, I think that covers those issues. Let's go ahead, Mr. Whitenauer.
Yes, Judge, and I hate to be the one to say there might be a little bit of a roadblock in this case, Judge. The state is this is not a negotiated plea. Most of the ones that we have on the count today are, Judge, but I had an opportunity to speak with Ms. Jones yesterday, and the state does have some concern about the fact that this defendant is, as I understand from speaking with Ms. Jones, homeless and has some drug and mental health issues. And so we want to be making a recommendation that would have him be released to the street until there's some sort of program identified, and that has not yet been done. And so I don't know that this one case on the calendar is exactly ripe for a negotiated plea. And I apologize for that hiccup. We have tried to work out the majority on the calendar, but we would be recommending some prison time if it were a non-negotiated plea, but are hopeful that maybe a program might be available. And I don't know if Ms. Jones wants to speak to that further.
Your Honor, the plea rec that was forwarded to us was the 25 served 10 backloaded. I spoke with my client. He thought that was a lot. So, and we just indicated we throw it up non-negotiated. We are aware that he is homeless. I am aware he's homeless, and my client is aware he's homeless. Ms. Cole is working on that, and we, although my client would like to be released, we would indicate to the court that we think that he probably should be held until a program is identified. And we certainly have those weekly conference meetings that we have, that if something pops up, we can talk about that. I do know, in speaking with Ms. Cole, that Stand actually is now doing virtual meetings. And she indicated to me that that's a program that's doing 8 in the morning to 2 in the afternoon. But they still don't have the bed space, but slowly things are starting to kind of crack open. So I think that we can go forward, Your Honor.
Let's go ahead and go forward and see where we get. Go ahead, Mr. Whitenauer.
Yes, Judge. Just give me one moment. So I have all the information before me.
May I say something, Your Honor?
Hold on just a few minutes, okay?
All right, sir, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter pending before this court be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Williams?
I'm getting kind of confused. I'm not knowing if I'm going to be released or if I'm going to go to a program. I don't want to mess things up. I got kind of confused there with the
That's
road.
okay. I will advocate for you. So just right now, just what we went through yesterday, just go ahead and answer the DA's questions with yes or no. Okay. And then I'll explain what we spoke about yesterday. Okay. When it's my turn.
Okay.
Okay.
All right. So, Mr.
ahead.
Williams, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office, and I am going to ask you some questions before the judge is able to make a decision about this case. So if you could please raise your right hand. And do you swear or affirm the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
It's the truth.
All
Okay.
right. Go ahead.
Yes, thank you, Judge. Sir, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
On medication.
All right. And is that medication affect your ability to understand what we're doing here today?
No, sir.
How old are you?
40.
How far have you gone in school?
8th grade, 9th grade.
Are you able to read, write, and understand the English language?
Yes, I am.
Do you understand that you're charged with the following offenses in indictment 20 SC 174-813, burglary in the first degree and criminal damage to property second degree?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And sir, have you had an opportunity to discuss the waiver of rights form with your attorney over the phone?
Yes, I did.
And do you waive signing that form? That is, would you allow the judge to sign that form for you?
To waive my rights.
To waive your rights, to sign on your behalf, because you're there and she's in the courtroom.
Mr. Williams, do you remember Ms. Jones going over your rights with you?
Yes, ma'am, I do.
Okay, she went over what's called a plea sheet with you, okay?
Yes, ma'am.
But you couldn't sign it because she was on the phone and you were there. The question is, are you okay with me signing it for you?
So if you sign now, I'm pleading out to this time.
If you don't, we're going through the plea right now. If you don't like the sentence, you can withdraw your plea.
Is I'm gonna be able to get out? I don't know.
I can tell you on the front end of this, you are not getting out of jail today or tomorrow. I would be considering a program for you, but you will not be released. And if you don't want to go forward under those circumstances, we can just stop right now.
No, I was wondering if I was gonna get some help with a program in house, and yes, ma'am, I do need that. That was the part of the plan we was trying to get. That's
Okay,
all.
well, we're not, Mr. Williams, we're not there yet. We have to go through the plea first
Okay,
before we can get there. So the question is it okay for me to sign for you?
yes, it is.
Okay, great. Go ahead, Mr. Whitenauer.
Thank you, Judge. And sir, is it also okay for the judge to sign the indictment?
Yes, it is.
All right. Sir, have you had enough time to speak with your attorney, Ms. Jones, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
She talked to me about them. Yes, she did.
Okay. And do you need more time to discuss the case with your attorney?
No, we went over everything.
Are you satisfied with her services?
Yes, I am. She is trying to help me. Yes, she is.
All right. And counsel,
Sorry
do you
about
waive?
the confusion.
That's all right. That's all right. This is a new way of doing things. Everybody gets a little bit confused. Okay? Go ahead, Mr. Whitenauer.
Thank you, Judge. Counsel, do you waive formal reading of the indictment?
We do for the purposes of this plea.
And do you waive any and all defects in the indictment?
For the purposes of this plea, yes.
And sir, has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
Yes,
Okay, so on count one, burglary in the first degree, that carries a sentencing range of 1 to 20 years in confinement. And on count two, criminal damage, that carries a sentencing range of 1 to 5 years in confinement. Do you understand?
yes, I do.
All right. You understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state may still make a recommendation to the court.
I do now. Yes,
Okay, and do you understand, and have you discussed the state's recommendation in your case
we talked about it.
of 25 years to serve 10 backloaded with the balance on probation to include certain conditions?
Yes, we talked about that.
All right. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
She told me about them things. Yes,
Okay. Do you understand that if you go forward with this plea, this will be a guilty plea, which is permanently recorded on your criminal history?
yes,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
yes. I understand.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes,
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
Do you understand that you're not allowed to possess or use a firearm while on probation?
yes, I do.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, I agree.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you?
Yes,
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
yes, it is. I
For
believe.
example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
yes, I am. Yes, I agree.
You understand that?
I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, I do.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself.
Yes, I do.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
I'm guilty.
How do you plead to the charges in indictment 20 SC 174813, burglary in the first, criminal damage in the second? How do you plead, sir?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Can I ask the judge a question? I know y'all like to go through this very fast. This is not my first rodeo. I know we're trying to get through this. Is it okay if I ask the judge a question before I plead guilty?
Go ahead.
Your Honor,
Go ahead.
You said I was entering a blind plea?
No. What I said was we were going to get through the plea. I was going to go ahead and impose the sentence. And then if you don't like my sentence, you can withdraw your plea.
How much you gonna?
I can't tell you that till we get through the plea.
Oh, I
Okay?
didn't know that. Oh, I didn't know that. Okay.
Okay.
I'm sorry.
You're not asking, your questions are fine. Don't worry about asking the questions, Mr. Williams. There are certain procedures we have to do before we can get there, okay? So
All right.
let's get through the plea. If you don't like it, we'll set it aside and throw it out, okay?
After you
Thanks,
say
Judge.
it, after you. Okay.
Go ahead, sir.
After you tell me the plea, if I don't like the plea, I can say I don't like it.
Yep. Okay,
That's reasonable.
okay, good. Go ahead, Mr. Whitedower.
Okay.
Sir, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, I'm guilty.
Okay.
Do you
but do
understand what you're doing?
Well, actually, yes, and no, I understand what I did.
Okay, let me ask you a question. Is anybody forcing you to enter this plea?
No,
Okay, great. Go ahead, Mr. Whitedower.
Sir, do you understand that you may have only a limited right to appeal this guilty plea conviction if you were to go forward?
yes, time's running out on motions. I do know that. It's a time limit on motions.
Okay, but you understand that if you were to enter this plea, you would have a limited period of time to appeal or to challenge that plea and that conviction.
Yes, I do.
Okay, and specifically, do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file what is called a habeas corpus petition challenging the voluntariness of this guilty plea? I'm just trying to inform you of a right, and I want to make sure that you're aware of that right, that you can challenge through what's called a habeas corpus petition that you entered this plea voluntarily.
I'm trying to keep it all together and listen and focus at the same time. Yes, I understand. I understand. I
Okay,
agree with
good.
what you're saying. It's
Okay,
just
go
a lot
ahead.
going on. Thank you.
Understood,
All
sir. All right, so now I'm going to give a brief factual recitation of this case, sir. So just stand by for a moment. Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about January 24th, 2020, officers with the Atlanta Police Department responded to 1032 Harwell, Harwell Street, Northwest in Atlanta, Georgia. They responded to a call of a male being in the house unlawfully. When the officers arrived, they spoke with a witness, Jorge Bejar, Bejar, who said that he was there at the owner's request. That's Eduardo Rognoni, Rognoni, to be there to fix a broken window in the house. While this person, Jorge Bejar, was at the house, he observed that there was blood throughout on the floor, on the walls, and the cabinets. And upon seeing this, he was about to call the police and then observed the defendant, Mr. Williams, exiting the house and walking away from it. Mr. Behar then took some photographs of the defendant, which I've shared with defense counsel, and he was later found outside of a quick stop nearby and placed under arrest.
Criminal history?
Yes, Judge. This defendant has 63 total arrests. Most of them are out of state. Of most recent concern would be those out of Tennessee, Judge. I spoke with the ADA in Knox County, Tennessee, and he has 8 convictions out of Knox County from as early as 1999 through 2018. Yes, for attempted false reports. These are just from the list that I received from that ADA: burn personal property or land, vandalism, wearing body armor while committing a felony, reckless aggravated assault, again, vandalism, Schedule 2 drugs, cocaine, and Schedule 2 drugs. It says ATT cocaine, so I don't know if that's attempted possession of cocaine, but that is what I received from the ADA in Tennessee. She also advised that this defendant has absconded from the jurisdiction of Tennessee, where he was on probation.
Is he still on probation there?
Your Honor, if you'll give me a moment, I can pull up that.
Do you understand the nature of the charge? I'll let you do that while I go through his rights. Do you understand the nature of the charges against you? Mr. Williams?
Yes, ma'am, I understand everything.
Are you now under the influence of any alcohol, drugs, or any other substances?
No, ma'am. And
Has anyone made any threat or promise to influence you to plead guilty?
Your Honor, I went in there.
Well, no. We got to get through the rights first, all right?
No,
Has anyone made any threat or promise to influence you to plead guilty?
No, they haven't.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, and the right to appeal your case and be represented by counsel if convicted by a jury? You understand that by pleading guilty, you're giving up all of those rights?
Yes, I understand. I'm giving up them rights.
Do you understand if you are not a U.S. citizen, a plea of guilty could have an impact on you, or would have an impact on your immigration status?
I understand that.
Do you understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate?
I understand that.
How do you plead to the charges, guilty or not guilty?
Yes,
Is your plea made freely and voluntarily?
freely and voluntarily, yes.
Ms. Jones, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
I do, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered. Go ahead, Ms. Jones.
Thank you, Your Honor. As my client indicated, he's 40 years old. He did complete the 9th grade, Your Honor. As the DA indicated, he is from Tennessee. He came here from Tennessee with a family member, Stacy Patchell. Your Honor, he has diagnosed mental health issues. And as we alluded to earlier, he has some housing issues as well. My understanding and speaking with my client regarding the facts of this case, and one of the reasons why we thought we could probably throw it up, is there was not an intention to steal anything. And I think that's what my client was trying to allude to. Mr. Williams, he indicated to me that he did break into this house because he was homeless, he was cold, and he just wanted to get in. And he was also off of his medications, Your Honor.
I went in there and split my wrist.
Okay.
That's where the blood came.
Right. Your Honor, I have spoke with my client as well, and he indicated to me that when he did move here, he was trying to get assistance. He had been going to Grady as well as Gateway. However, the price of the medication became too much, and so he had to stop taking his medications because he was trying to get his Social Security up and running, Your Honor. So he has a track record of having Social Security, which is a good thing. I talked with Ms. Cole about him as well as some other folks yesterday. And unfortunately, he's just one of those folks that she was not able to really speak with and get a good feel in terms of what program would be good for him, although she did mention some that she thought would be good, including First Step, because they help with Social Security, as well as maybe Stand or the Trinity House, Your Honor, because he's a dual diagnoses. Or Grady, because he has a track record, maybe an ACT team or something along those lines. I know Mr. Williams does want help. I know that he doesn't necessarily want to be released to the streets unless there is a program for him. We talked extensively about that yesterday, and I think that's a little bit why he's a little nervous in terms of he wants help. And I think the fact that he was trying to get help on his own, but wasn't quite as successful is indicative, Your Honor, that he is motivated to try and stay on his medications as well as address his housing issues, Your Honor. And Ms. Cole is actually working on that, Your Honor. It's just been a little bit tough since visitation was down, and we've been using phones, which now I know may be an issue going forward, but we'll cross that bridge when we get there, Your Honor. But he is high on her list. We would request a probated sentence, perhaps a backloaded sentence. I tried to explain that to him yesterday, what that meant. I think he understood, Your Honor. But the big thing here is we think he needs a lot of structure. We're not opposed to structure at this time, Your Honor. We just don't, and I know my client doesn't either, necessarily want to be released without that structure in place. And we also spoke that if Your Honor was inclined to give him a program, that he would waive his presence for any future hearings so that we could just get him to that program. However, I indicated I would speak with him via the phone or visits if it's now, if we have visits, so he understands completely what is expected of him, Your Honor.
Okay. All right, on count 2, 5 years probated. Count 1, 20 to serve 8, backloaded. Special conditions of the sentence are entry into and completion of an inpatient treatment program, a minimum of 9 months. He will not be released until that program is found and approved. Any aftercare, you have to stay on your medication, random drug screens, report to court once a month or as directed.
Your Honor, and I just wanted to follow up on one question you had. The ADA in Knox County said that he is currently under supervision of the Tennessee Department of Corrections, has absconded from supervision, and he has a few months left on his sentence. That email was sent on April 1st of this year. Judge, also, and Ms. Jones, I apologize, I received this email at 12:24 this morning from the owner of the house, and he is asking for restitution in the amount of $3,000.
We'd set it down for a restitution hearing.
Yes, Judge.
Okay, I need to jump on this other call. That'll give you a minute if you want, Ms. Jones, to see if he understands what's going on and if he wants the sentence to stand. All right, I'll be back as quickly as possible if y'all can just kind of hang tight. All right?
Perfect, thank
Yes,
you, Your
Judge.
Honor.
Tanya, do you want to
understand that?
speak with him privately, do a breakout session?
Yes,
I mean, an idea.
I have to speak to Michael.
Let me ask you, Mr. Williams, are you comfortable with what just happened?
Yes, I am.
Okay, all right. So I will have Ms. Cole is going to come speak with you again, either by phone, or we're now doing video visitation. So it'd be like this, except just you and Ms. Cole, okay?
Thank you very much.
You're very welcome.
Free to leave? No.
No.
Judge. Okay. Gotta wait.
I think there's a probation matter as well, maybe.
I don't think he's, no.
Mr. Allen,
Yes, I got the 20 serve 8 backloaded, so that means he has probation time.
I thought you meant a probation revocation. Sorry.
I'm going to go on mute for a moment, but I will be back.
If the administrator or the host could break us out to a private session so I can get his personal information.
Good luck, Mallory.
I think there's someone on that can do that.
Okay.
I'm gonna.
Good morning, Ms. Jones.
Yes.
This is Kareem McPherson from Accountability Court. How are you?
Good, thank you.
I don't know if you saw my inbox on the chat that I sent you, the message. No.
Well, I see it, but I don't know.